So good afternoon, everybody, and welcome to the last of our closing webinars for the AI in English Law project based here in Oxford. And our focus today is going to be on tomorrow's legal teams, the roles, education and training that those teams are going to need. And in doing that, we're going to be examining the results of the fourth and fifth work streams in the project. So the first set of presentations will focus on the demand for technological skills in legal services, and we're going to hear from Adam Saunders and Matthias Kean on that subject. Adam is a researcher in the Department of Education's Centre on Skills, Knowledge and Organisational Performance, shortened to SCOPE, and he and his team will be presenting his web tool. Matthias is a research fellow in finance and AI at the Said Business School. And after we've considered the demand for these skills with Adam and Matthias, we'll then start to look at how we might supply that demand and build capacity in the kinds of skills that they've been discussing. And in particular, how we can train people for the multidisciplinary needs of the current and future workplace. And the focus there is going to be on the work stream with which I've been involved, along with my colleagues Hewitt Keep and Václav Janacek. Hewitt Keep is an emeritus professor of education, training and skills at the Department of Education, where he was the director of SCOPE, and he's published widely on the formation of skills policies in the UK and has advised various governmental bodies. Dr. Václav Janacek has been a research and course development fellow in law and technology based here in Oxford at the law faculty as he's worked on the project, but he is now currently at Masaryk University. I should also add that although Hewitt, Václav and I will be the ones presenting, absolutely crucial to our success in that work stream has also been the input of Professor Tom Mellon from the Department of Computer Science. So then, following our presentations, I will hand over to Professor Richard Susskind to chair the panel discussion. And Richard, of course, needs no introduction, but is, among other things, technology advisor to the Lord Chief Justice and a visiting professor at the Oxford Internet Institute, as well as the author of several books on the future of lawyers and law in the digital age. Joining him on the panel is Nigel Spencer, Professor of Education, Innovation and Professional Practice at Queen University of Law, having previously been at the Said Business School here in Oxford, and before that, Global Director of Learning and Development at 2 international law firms. Ruth Ward is Director of Knowledge at one of our project partners, the Government Legal Department, and Ruth was formerly Head of Knowledge and Collaboration Technologies at Allen & Overy, one of the city's leading law firms. Emily Liu joins us from another of our project partners, Slaughter & May, where she is a Senior Knowledge and Data Innovation Manager. And our final panellist is a fellow academic who I first met because of the exciting work he was doing in law and computer science, and that is Professor Andy Unger, Head of the Law Division at London South Bank University. So we're really looking forward to hearing all of your comments, but first of all, I will hand over to Adam and his team to begin the presentations.
Thanks very much, Becca. We're going to be showing a web tool, which I think we can start to put up at this stage. And our project has centered on what's called Work Package number 4, which looks at the impact of technological innovation on skills in the labour market, with specific reference to the professional service sector. And we've focused quite a lot on all the different ingredients that have made up the changes that we're starting to see, both within businesses and what are required from the employees who work within businesses, within legal services, insurance, and also accountancy. More recently, we've expanded our focus to look at also what's going on in financial services, management consultancy, and some others. So all those that are considered to be high value-added professional services. The project has recently received an extension from UKRI to develop a web tool. And that's what we're going to be showing today in terms of bringing the different research pieces, the different results into one basically warehouse to show visualizations of this. And quite like the changes that we've been monitoring, our team has adopted a lot of these different roles within the team, develop these different capabilities. So we work with big data. We work specifically with online job ads that are derived from the web and then are analyzed using different data science techniques and machine learning techniques. Lattice is going to be talking about some of the machine learning that has been done to predict salary residuals in this project, and that's shown also on the map that we're going to show that you saw a moment ago. Also, we were doing work in skills pricing, so pricing the actual value of individual skills, so not just the salaries of job roles. And then finally looking at the extent to which there's demand reflected in the counts and proportion of counts in terms of employer interest, employer demand for these different skill sets in the professional services sector. So I'm going to hand it over to Gattis to talk about the salary residual work that he's done, and then we'll move from there to hear from Tom. I'll come back to talk about a few insights from the tool. Over to you, Gattis.
All right, thank you, Adam. I understand I only have 2 minutes, 2.5 minutes to present the idea of what we've built. The first point was to look at the job text and the salary that such a job offers. And well, it's very interesting, it's very relevant. And yes, you can build machine learning models that read in the text and predict the salary with reasonably good accuracy. And also you can train more complex models that actually highlight the words which are most relevant, most interesting for the algorithm. But in discussion with, in particular, Matthias, we thought we could do something more clever. That is to say, we will take the same job and transplant it from the location in which it actually was to different locations. That is to say, you can't move a real job in a real economy from London to Belfast. But what we can do is we can ask the network, the neural network, to weigh the evidence and give us an estimate of how much the same job would pay you in salary in Belfast, if it was in Belfast. So that's the system we've built, in which ceteris paribus, we take the same job and give it a different location. In this way, building an estimate of residuals, which is interesting for economists, but in particular here for profiling different regions and cities within the United Kingdom, and giving us an estimate of the penalty or the premium that an employee would pay for the same job in terms of getting a bit extra in terms of pounds per year on top of his salaries by virtue of this job being in London, say, or getting a bit less. So that being a penalty, again, getting a bit less British pounds per year just by virtue of his job being somewhere else. So that's the figure we're trying to estimate, and that is what we've built using attentional neural networks and the big data set of UK jobs that we have at our disposal.
Great, thank you, Gattis. I'm going to give a quick high-level non-technical overview of the methodology that I've been using in the skills analysis side of the project. So we've been using data from Burning Glass, and we've had access to UK job adverts that cover the period of 2012 to present day. And hopefully this answers one of the questions that was posted in the chat. So we once filtered, I've been using about 27 million job adverts over that period. And each job advert can contain information about the employer, the job title, the location, the salary expectation, and some key skill terms that have been extracted from the source. These are the canon skills that we're going to talk about later on and show on the map. We also have the job text, which Gattis has been using, and the SIC and SOC codes that are generated by Burning Glass and assigned to each job advert. So our first task was to investigate the frequency at which skill terms appear in the data across all of the job adverts. We also looked at the proportion of job adverts that mention a particular skill. And it's quite important to consider this relative measure, as the total number of job adverts fluctuates year by year. So by evaluating the proportion, you have a sort of a better idea of the true growth within the total corpus of job adverts. And from this, we can look at the skill terms and identify what is growing in demand in the UK across all job adverts, and we can also identify what's falling in demand in terms of skills. And then using geographic tags attached to each job advert, we also consider where in the UK there is change in skills. So we've performed this on a city-wide and a local authority district-wide level. For the skills pricing itself, we constructed a linear model using a mini-batch stochastic gradient descent. And the skills are represented as dummy variables and regressed against the salary. And when using the very large data set we have available, this method allows us to analyze the contribution of each skill to a salary. And then aggregating the adverts year by year and performing the pricing analysis allows us to see the sort of demand side value of each skill and how it varies over time. And this is particularly useful when trying to identify skills of emerging importance, particularly when looking at sort of new emerging technology skills that are being adopted by certain sectors. And then finally, which is most relevant to this talk, we separated the data using the SIC and SOC codes provided by Burning Glass. And from there, we broke down the data into the individual levels for each of these codes. And this allows us to investigate the counts, proportions, and prices of all skills across the country and by regions at different levels of industry and occupation code. So hopefully, Shiv, if you could share your screen, we can see an example of how we've looked at a certain, a small portion of technology and domain skills within, for instance, the legal, insurance, and finance sector as a demo of our tool. And I'll now pass you back to Adam for some insights.
Thanks very much. Shiv, if you could actually leave up the web tool. So as I was saying before, we had an extension to our project from UKRI to build this web tool to be able to provide internal insights to UKRI in its own decision-making about how the labour market and the economy as it relates to professional services are changing over time and what can be expected in the future. As Tom was saying, and as Gattis was saying, we have two essentially different insights that we're showing on the tool right now. So the first part, which is salary residuals, shown on the map, is showing some very interesting things. The first one we sort of knew going into this project, which is that the center of gravity for professional services, the premium in terms of salary for skills, is in London. The other thing that we learned along the way, and that was actually through some count analyses that we did, was that also Belfast has become a big centre for tech skills as a place which is sort of an onshore outsourcing location in the UK for legal services and for auxiliary services for legal services. And so you can see that the bookends of the UK labour market for legal services are framed by London on the one hand, with the highest premium, and Belfast on the other, except for the fact that what's quite interesting about that is that Belfast also has quite a lot of skill demand relative to other locations, Manchester, Birmingham, other large cities in the UK, for these tech skills, including machine learning within legal services. So that was actually quite interesting to try and look, sort of piece that together. The other interesting thing is the change that's happening that we didn't expect within London based on the salary residual work, which is that the City of London, the square mile, is where we would expect to see the greatest demand and also the highest premium for legal services skills. Just as an assumption, a hypothesis going into this. What we're seeing actually over time is that the wider county of London has started to assume a greater premium than the City of London itself. So places like Kensington, Hackney, Camden, and others. Some of this may relate to the tech side of the legal tech side, and we have to investigate that further. And then I'm just going to conclude with one final insight, which is looking at the differences between the pricing, the value of skills within the domain side of legal services, but we've done it for some others, as shown here, for insurance, and the tech side. So there's an appreciation, as we might expect, for a number of these technology enabling skills. So things like software development and engineering, machine learning, big data, data science, cloud computing, all of these sorts of skills that enable basically software as a service business models. But in addition to that, there has been a sort of mixed picture with domain skills. So some domain skills have been decreasing over the course of time in terms of their value, while others have either been maintaining their value or increasing. I think what that starts to do is to show us insights about what human-centered knowledge is increasingly becoming valued alongside the technology skills, and which is depreciating over the course of time. So I'll leave it at that, and we're very happy to take questions in the Q&A.
Thanks very much, Adam. Matthias, shall I just hand straight over to you?
Yes, super. Just putting up the screen share, starting my timer. Okay. Thanks, Adam, for the presentation. That was great. In the next part of the presentation, we'll present a project that looks at the future of professional work. That project is jointly with Mari Sacco and Jacopo Attolini, and has grown out of SRA report on digital technology and innovation in the legal sector. The aim of the project is to examine how digital technology is changing professional work from the lens of professional control as a mediating factor. And we're combining the future of work literature from the economics profession with the systems of professions literature from sociology. And our starting point is a realization that digital skills and digital tasks will need to be included within the legal sector. But how they will be included will depend on the professional control. And that when there is more professional control, then these tasks will be under the full jurisdiction of the kind of high profile occupation, which is the lawyers, and their subordinate jurisdictions, which are the paralegals. And if there is weaker professional control over the tasks, then there will be a division of labor. And there may be jurisdictional settlements where lawyers share these tasks with other high-profile occupations such as data scientists. We'll test these hypotheses using burning glass data, the same data set that Adam has presented on, and kind of evaluate the number of hypotheses that we derive with this. To characterize the theory, I want to start with the observation that if you ask the experts today what share of jobs are at risk, then you get a huge range of estimates, right? So it starts at 9%, that's the view of the OECD, and it goes up to 96%. And what you have when you get such a wide range of the kind of jobs at risk doesn't actually tell you much. And the reason it doesn't tell you much is, of course, data and methodology. In terms of the methodology, some of the studies are looking at automation in general, and others are looking at AI in particular, and kind of how AI will then affect the tasks that are affected within the current job roles. And the focus on tasks is the main kind of guiding kind of way to think about the future of work from the economics perspective. Here we say that technology will create a need for digital skills, and these skills will impact tasks in three ways. They will substitute tasks, they will augment tasks, and they will create new tasks. So within the legal sector, substitution could be that junior lawyers would have to do less document review because more of the document review is done automatically. Augmentation can be in twofold. On the one hand, it can be lawyers as producers of digital technology, such as being a legal engineer and then develop the software packages, or as consumers of the digital technologies, where they would say use Lumen's tool to be more productive in executing M&A transactions. And then finally, with the creation of new tasks, it could include tasks such as a consideration of the ethical implications of artificial intelligence, and that could be reflected in new certificates required for jobs in documenting the expertise. The second block of literature that we're using for this paper is the sociological literature on the systems of professions. So, that is one of the sociological theories that has direct implications on tasks. And it's instructive to read Abbott's quote on this matter, which is the central organizing reality of professional life is control of tasks. The tasks themselves are defined in the profession's culture of work. Control over them is established by competitive claims in public media, legal disclosure, and in workplace negotiations. So we focus on the strengths of the professional control, and the more strongly organized the profession is, the more effective they are in controlling and excluding other professions, importantly, from executing and doing these tasks. Based on the theory, we derive 3 hypotheses. So a starting point is the observation that when there is more professional control over specific tasks in the legal sector, then lawyers may want to have full jurisdiction over these new digital tasks, so they will become coder lawyers, or a subset of the lawyers will become coder lawyers, or they can delegate these new tasks to their subordinate jurisdiction, which are the paralegals. And there are 3 ways to measure strength of professional control. We use the regulated versus unregulated sector. We use the US and the UK, where the US has more professional control of lawyers over the tasks. And certainly there is a difference between the legal and the non-legal sector. We find support for our hypothesis when we do the comparison between the US and the UK. And then similarly, if there is weaker professional control, then there's more room for a jurisdictional settlement and the division of labor, such that lawyers may choose to work in multidisciplinary teams with, say, data scientists to develop the technologies. And therefore, we can make predictions on non-legal occupations and how professional control will affect the adoption of digital skills within the legal sector for this group. But for this group, we actually do not find strong evidence that professional control affects the rate of adoption of digital skills within these job roles. And lastly, we look at salaries, and with salaries, the associated pay premia. So how much does it pay more for a lawyer to know digital skills? And we will actually find that in the US, actually that for the salaries and pay premium is negative, and you have a lower salary, and in the UK you actually have a premium, so you are paid more if you can have digital skills as a lawyer. A brief, quick tour through the data and the methods. So we differentiate between sector and occupations. So here on the rows, you see the sectors, the legal and non-legal sector. And in the columns, you find the occupations, which are the lawyers and judges, the highest ranking occupations. And then there are subordinate occupations of other legal professionals, including paralegals. And then lastly, non-lawyers within the legal sector. And this analysis is based on big data, in the sense that we have millions of job ads that we base this analysis on. Here are the terms that we use to filter for digital skills. They include artificial intelligence, AI, machine learning, deep learning, and then extend to a number of other terms that capture digital skills. And when we look at the kind of most prevalent skills of the job postings in the legal sector without digital skills, so the first worked out, you see that litigation is the most prevalent, and then don't see many more digital skills because this has job ads that don't include digital skills. In contrast, if we look at the job postings with digital skills, then it's keywords like document reviews that dominate, and terms like Microsoft C# or .NET, which are tools that are used within law firms to deliver digital platforms. Okay, so let's look in depth into the key findings that we have within this study. So here is a test of the first hypothesis, which compares the regulated and unregulated sector in the United Kingdom. And on the y-axis, you see the share of the total jobs that have digital skills. And one of the observations is it's low in both sectors. It's lowest for lawyers, and then it's the highest for non-legal occupations in the legal sector. But there are no substantial differences in the share of digital skills within all the job postings. So we do not find support for the first hypothesis. However, we do find support for the second hypothesis when we compare the US and the UK. So if we look at the left panel, which is the UK, we see kind of the low rates of digital skills within all job postings. But in the US, it's a step change, substantially higher. So more lawyers in the US actually are required to know digital skills as per the job postings. And that's the same for their subordinate occupations, such as the paralegals. Then if we look at the non-legal sector, here we look at lawyers and other legal professionals, we find the same step change, and that the level of the share of the job postings that have digital skills is higher. In the third margin of comparison, which we can consider when we measure professional control, which is to look within a country and to compare between the legal and non-legal sector. We would expect from our theory that in the sector with stronger occupational control, which is the legal sector, we would have a higher share of lawyers who can code, but we do not find evidence for this. In fact, they are about the same share of job ads that require digital skills across both sectors. And it's the same for the US. If we look at the legal and non-legal sector, then the share of the job ads that require coding skills are about the same. So there's no support for hypothesis 1C. And then in the second set of hypotheses, we look at non-legal occupations. Like we've argued before, that when you have a weaker professional control, then you're more likely to engage in jurisdictional settlements where you have a division of labor of these new digital tasks with other high-profile occupations such as data scientists. But when we compare the regulated sector in the UK with the unregulated sector in the UK, for the non-legal occupations, which is a dashed line, they have about the same level. So there is no evidence that there is in support of this hypothesis. And similarly, if we do the cross-country comparison and look at the dashed line for the UK and the US, then they're also at a similar level, which suggests that in the country with a weaker professional control, which is the UK, there's no empirical evidence that the non-legal occupations have a higher share of job postings that have digital skills. And moving on to the last set of hypotheses, which looks at the salary. Here you have a table of the median salary of vacancies with digital skills and without digital skills. So you have here in the rows the different occupations, starting with solicitors, legal associate professionals, legal professionals, legal secretaries, and barristers and judges. For the legal sector, which is the first panel, and then the second panel below is the non-legal sector. And you can see that the median salary for solicitors is about 50,000 pounds. If you have digital skills, and without digital skills, it's 45,000 pounds, which means that the difference in the median salary is 5,000 pounds for a solicitor, and that you earn more, 5,000 pounds more, if you do have digital skills. And similarly, if you are a legal associate professional, then, which is like a subordinate occupation, you see that the salaries are substantially lower. So the median salary with digital skills is 28,000, and without digital skills is 22,000. So the difference is 5,500 pounds. And you get a very similar picture if you look at the non-legal sector. In fact, the median salary is exactly the same of a solicitor in the legal sector and outside of the legal sector. And the pay premium is also the same at 5,000 pounds. So if we compare this to the United States, then you will notice that it's the opposite. So the kind of solicitor category in the United States is called the lawyer. And the lawyer has a median salary, if he has digital skills, of $66,000. But if he does not have digital skills, then it's $90,000. So the paid premium is actually a pay penalty. And it's 23,000 pounds less salaries if you are a lawyer in the US with digital skills, which suggests that it may actually be a negative signal in that if you emphasize kind of with the professional control, the exercise of the core skills you regard as legal skills, and if then you see a lawyer that has additional skills, you may think he's not focusing enough in the education on the most important legal skills that justify the value, but instead kind of spends time on tasks and skills that you do not consider essential. And therefore, there may be a penalty, and that it may be the perception that the best performing lawyers in the US would not invest in such skills, such as digital skills, because that would be a negative signal to their strengths of their legal skills. And that is in support of hypothesis 3A, which we had, which suggested that if there is more professional control, then there is a lower pay premium for digital skills. And then the last margin of comparison is within the country. So we compare legal and the non-legal sector with the understanding that in the legal sector, there's more professional control of lawyers. And we do find slightly higher salaries for digital skills for the legal associate professionals, which are at 6,000 instead of 5,500. the pay premium is actually the same for solicitors. And in the US, we find the same for lawyers, in that in the non-legal sector, the pay penalty is lower outside of the legal sector. It's only $10,000 instead of $23,000. To conclude, we've used the combination of two literatures, two academic literatures, the future of work literature from the economics profession and the system of profession literature from sociology, to try to understand the implications of including digital skills within the legal sector. And I mean, how will the future look like? In practical terms, we think it depends on the professional control. So if there is a lot of professional control, then we expect the emergence of more lawyer coders. Oh, I just finished this one sentence, and I'll finish. Can you stop this beeping? Who's doing the beeping? We will not stop. Okay, then I just speak while the beeping continues. And the last idea is, if there is less professional control, then there will be more of division of labor and the kind of coexistence of lawyers with non-lawyers. That's all.
Great, thanks very much, Matthias. And I think we can get a handle on the beeping wherever it is coming from. In that case, we can move to the second set of presentations and begin with you as we start to think about how we're going to build capacity and the different skills that we need.
Hi, good afternoon. I'm going to be talking about a project that was really looking at the future of legal education. And it's a project that's not just a research project, but also action research. There's actually a practical intervention. And this project was undertaken by myself, by Rebecca, by Vaclav, and by Tom. And as you'll see, it's an interesting experiment in trying to do something as well as think about something. Still pressing my, here we go. Big picture. Okay. I think I'm here to sort of set the scene. And I think the key thing to say is that what we're at the very start of a long journey. It's not just the UK that's worrying about this in terms of legal professions. Most developed nations are worrying about the impact of artificial intelligence on jobs and the shape of education and training to respond to that across the developed world and beyond. And we're at a very early stage. And I think as a historian, one of my sort of warnings is that what happens in the early stages of the adoption of a new technology are not necessarily a good predictor of what will happen later on. I can remember working in Warwick Business School in the 1980s when IBM PCs arrived. And the management of the business school had no idea what to do with them, except that they would probably be useful for the professor's secretaries, so they could write their letters on a nice word processing program rather than a golf ball typewriter. Obviously, that wasn't a particularly good predictor of what computerization would do to the academic life and the shape of academic jobs. So I think, we have to be clear that what we're doing and thinking at the moment, we're responding to the early stages of something, and the future may be very, very different. Oh, I'm sorry, can I skip Vaclav? How do I skip back? Sorry, thank you. There are lots of factors at play. And I think one of the key things is about the way in which roles will change over time. Existing job tasks are going to be rebundled. They may be put under new jobs, and that's plainly part of the story that Matthias has just been telling us about America. New business ownership and business models. Well, we had another work package which is on that, which has been a subject of an earlier conference presentation. Not today's. And this is going to change traditional law structures over time. So, for example, if you're busy trying to train paralegals, the big question is 10 years from now, how many paralegals will there be? Because a lot of their jobs are possibly vulnerable to what artificial intelligence can do. What will they be doing 10 years from now? Be very different, I suspect, from what they're doing. From what they're doing in the future will be very different from now. and how will education and training have to change to meet that? Sorry, I'm clicking and nothing's happening. Change with multi-speed. I mean, it's absolutely important to recognize that one of the things that will differentiate what's happening is different sectors, different law firms, different sizes will react very differently. So, what Slaughter and May do will be very different in terms of what they do and how quickly they do it to what my family solicitors will be doing in the little market town of Ledbury. So we have to recognize that the rollout of this technology, its impacts will be very heavily differentiated, and that's a challenge for educators because we have a one size relatively fits all model in terms of what's on offer within the education system. So that's another little challenge. So what are the potential responses? Well, we could do nothing and wait and see what happens, but that's not possibly a very good model. It's certainly not the one that we've adopted. Secondly, redesign bachelor's and master's programs. And that's going to be important, but my warning to you is that the output of the entire output of the education system in the UK in any given year is equivalent to about 2% of the employed workforce in the UK. So whatever changes are made in undergraduate and master's education, their impact on the overall shape of the skills within the workforce will be relatively slow. And I do think there's a major issue about the way in which artificial intelligence and digitalization is introduced into legal CPD opportunities, because otherwise we're going to lag behind. And there's a dilemma about what to offer, which Rebecca will have a lot more to say about. But of course, basically the Shadbolt review of computer science showed that different employers want different things. Some wanted specific software packages and technologies and basically plug in and play employees. Others wanted courses aimed that would produce a general awareness of the technology and what it could do and what issues were thrown up. So do we produce lawyers who code, or do we bring lawyers and computer science people together to develop a shared understanding and language? And this is my final slide, at the back of our minds is a long-standing complaint about English higher education, which is that it's very good at developing people with sort of individual intellectual skills, but it's possibly not very good at developing the kinds of broader generic business skills which most employers say they want from graduates. So perhaps when we're thinking about AI and the law, there's an opportunity to tackle this background issue. So that's me finished, and I think it's over to Václav.
Thank you, Jort. Okay, so we've seen the bigger picture now. But what we really wanted to do in this larger or broader context was to try and identify the more specific set of skills and knowledge that lawyers will need to develop various technologically enhanced, or to provide various technologically enhanced legal services. And so, as you may remember from our first webinar, actually, our colleagues in Work Package 1 has done this marvelous survey of solicitors to learn, more statistically speaking, how big a demand there is. And it turned out that around 90% of lawyers actually think that they will need some learning or some education in law and technology in the next 3 years. But obviously, these are just very generic terms, education, law, and technology. And so we wanted to point our finger to what it is that these specific skills and knowledge needs are. And the way we did this was essentially we did a series of interviews with various professionals, legal professionals. And at the same time, we designed an experimental course in law and computer science to actually test how this plays out in practice. So in this part of the presentation, I will just very quickly present the results of our interviews. So on the basis of this, there were interviews with 19 subjects, 19 professionals in the legal profession, most of whom were London-based lawyers working for relatively large, but also medium law firms. And so what we found, it turned out that we can, roughly speaking, we are happy to discuss this afterwards, or you could read our research papers if you want to learn more details. But it turned out that there are roughly 5 broad skill sets that are needed. The first and the most important one is mindset understanding, by which we mean the gaps in between how lawyers and computer scientists, or more generally people working with technology, how they think about these issues, how they implement various technologies, how they address new problems, and what their cultural background is, what their working habits are, what their assumptions are, and so on and so forth. So this broad category, mindset understanding, really was one of the key obstacles that was identified through these interviews that essentially prevents lawyers to working more efficiently with technology in their practice and to start developing new solutions. The second was data-oriented thinking. Here, just very briefly, this really is a need identified by the interviewees on the basis that lawyers really do not regularly think about their daily work as data. They do not think of themselves as producing data along the way. Rather, they address various legal issues on a case-by-case basis, which is understandable. We want to have a just outcome. But it would help in order to essentially start providing these tech-enhanced legal services that lawyers learn how to think about themselves as data producers, and so that they see how the data might eventually be used. The third area that was identified through these interviews was commercial awareness. Now, obviously, there are all sorts of aspects to commercial awareness, but what resonated perhaps most strongly was the need for lawyers to be able to identify these real-life constraints, both in terms of time, but essentially and mainly in terms of the budget, because as I'm sure all the lawyers who are here in the audience today can appreciate, there is only a limited amount of money in each law firm that can be invested into these developments. And likewise, the clients would not be willing to spend huge amounts of money into solutions that are not yet tested, and so on and so forth. So this kind of commercial awareness is really a must for this common core of law tech knowledge and skills. The fourth area lumps up perhaps most diverse areas, but we call it agile systems and design thinking. And in relation to this area, our interviews have pointed out that lawyers will need to be more agile than they are by their very nature, because lawyers are generally very risk averse and resistant to change. They also will need to think more systemically, in the sense that they should see their various tech-enhanced solutions in the context of the broader working of not only the legal system, but also their own organization. And this is a skill that is currently lacking, because lawyers normally focus rather on their specific subset of problems. And finally, design thinking is a skill that was very regularly mentioned. I will not go into the details now. And the fifth, final area was law and ethics of digital technology. And here, what really was highlighted by our interviews was that, and this relates to Matthias's presentation as well, that lawyers, after all, are lawyers, and that their main trade is in the provision of legal services. And so they should be able to master the specific knowledge that applies to all these technologies, which is, by the way, very important also for the development of these tech-enhanced legal services, because all sorts of legal regulations and ethical questions will be important for that development.
Great, thank you, Václav. And so one of the other things that we wanted to do is to think about, well, let's set this in context in a law school. What does all of this mean for law schools in the 21st century? But it's important to remember that this is not just about the impact of technology, as you were saying, but also about broader trends. And in particular, even apart from technology, there's been a lot of discussion, a lot of reports written suggesting that maybe lawyers need to be what we call alphabet shaped, the various suggestions that they should be T-shaped or D-shaped or O-shaped, better rounded, in other words. So not just lawyers, but to have other skills as well. But what has become clear to us is that however useful these other alphabet skills might be, they are in addition to, not a substitute for, that core stem of legal knowledge that Václav was just referring to. And this is something that Nigel Spencer has written about, and also Richard Susskind, both of whom you'll hear from later. And it was really encapsulated in one of the things that one of the interviewees said to Václav, which is, we are going to continue to look for really strong academics. So these other skills might be important, but they're never going to replace that core stem of legal knowledge. It's also important to note that it's not really an either or either. We tend to think of law schools as producing people who are very well trained in the law, and that being what we're about doing. But actually, a lot of the other skills that these reports suggest are desirable are also very much part of a university education. So if we look at some of the things that the O-shaped lawyer report refers to, or the interviewees that Václav spoke to refer to, they talk about things like strong technical capabilities and intellectual agility, or the ability to analyse documents and think 20 steps ahead, the ability to take a giant pile of documents and analyse it thoroughly, resilience, comfort with unfamiliar areas. Well, these are absolutely core to even a very ordinary undergraduate law degree. So in some cases, I think it's as much about recognising that these are already things that we're teaching and labelling them as such as we teach them, explaining to people who are learning these skills that they are learning them. And that's both as far as the students themselves are concerned, and also as far as their future employers are concerned, just that sort of greater awareness and more conscious labelling. But there are, in addition to that, some things which I think law schools might usefully consider doing. And one of them is to realise how much more lattice-shaped career structures are increasingly becoming. So rather than people staying with one firm and moving gradually up a sort of ladder-like hierarchy for the whole of their career, we're seeing a lot more in the way of lateral moves into interdisciplinary areas and so on. What that means is that there is a reduction in the focus of single employers as a continuing source of continuing professional development. So if your one employer for your life is not going to be your source of continuing professional development, what that means is that there is then an ideal opportunity. There's a gap into which universities can step. And this was very much our thinking behind the launch of the Oxford Law Tech Education Programme, which Václav will talk more about in a moment. And universities are able, in doing that, not just to draw on market demand, not just to do what the market wants, but the other reason it's good for universities to work in this space is because we can also draw on a very strong, objective and independent peer-reviewed research base. So it's not just about giving people what they think they want, but we can also inform that with our own research. So we're ideally placed as universities to have an input, yes, into that education, but also to undertake thought leadership and guidance of the field themselves. And there's also lots of potential within universities for interdisciplinary law and courses, in particular law and computer science. The very inherently multidisciplinary nature of universities makes them absolutely ideal grounds to produce this kind of course. And so that then gets us on to our law and computer science course, which Hewitt and Václav have both talked about already. There are the two cohorts who have been through the course over the course of the project. We didn't really need to label them because you could guess which cohort was which. We have the nice in-person cohort that we managed almost to the end of the first academic year, and then the exclusively online cohort, which we managed equally well with last year. And if we sort of talk to you a little bit about what we've done on that course, it is, as we say, an absolutely 100% multidisciplinary, interdisciplinary course. We take 15 law students and 15 computer science students each year. So we have absolute caps and limits on numbers, and we make sure that we have 15 of each to keep that 100% balanced nature of the course. The core of the course are 16 lecture seminars, which are delivered over the first 2 terms of the academic year. And again, every one of those lecture seminars has an academic at the front of the classroom from the law faculty and an expert at the front of the classroom from the computer science faculty. So they are, again, absolutely completely interdisciplinary. However, the other very different thing, certainly very different for the law faculty, that we have done on this course is that in addition to that, we also have a practical project stream where we put the students into groups of 6 students, 3 computer science, 3 law students on each team, and we ask them to create a product or service based either on smart contract technology or using NLP, with the very fantastic help of Matthias Kian and Alistair Janssen van Rensburg, our 2 practical project supervisors. In the second year of the course, so last year, we were also very fortunate in that under the guidance of Stuart Hopper, we were able to add to that practical project stream a panel of industry mentors who were able to talk to our students all the way through, hear their initial pitches for project ideas, talk to them all the way through the developments of those projects, and then listen to their final project presentations at the end. And that has been an absolutely fantastic experience and resource for the students on the course. So the output of all of this is that we have graduates that we think of as being bilingual. So we don't teach the lawyers to code, although actually quite a lot of them pick that up along the way. We don't teach the computer scientists to be lawyers, although again, quite a lot of them pick up quite a lot. And very interestingly, towards the end of the 2 terms, when we have our guest expert lecturers come in, very often they can't tell whether the questions are coming from a computer science student or a law student. So the lecturers who join us towards the end of the course are not always sure of the background of each individual student that they meet, which is interesting. The practical projects themselves have generated several potential projects which students say that they would like to carry on and maybe think about doing as startups at some point in the future, which is great. We have also, as I say, through this panel of fantastic mentors, had a great deal of industry engagement, which has really added a fantastic dimension to the course. It's also led to a lot of cross-departmental research when we have an expert from each of 2 faculties at the front of the classroom discussing new problems that haven't been thought about before. That inevitably generates research as well, and there have been several pieces of research that have come out of the course. And as Václav will talk a little bit more about in a moment, it has also given rise to a lot of what we do on the front of executive education. So if I just remind you of that pentacle of the different skills that Václav was talking about before. What we do in the course is to try to cover all of those skills, at least to some extent. So if we think about the first one, that requirement of mindset understanding, teaching the 2 disciplines together, having 2 faculty members, 1 from each discipline, having absolutely balanced numbers of students and getting them to work together very much does help to bridge that gap. And that, of course, takes place both in the theoretical sessions, but also in the practical sessions where they have to work together to produce a particular product or outcome. But we also, in the first section of the theoretical course at the beginning of the autumn term, we talk a lot about interdisciplinarity, and we talk about the different cultures of the 2 disciplines and what we might find different or alien about the other discipline, and how we're going to overcome some of those gaps and what the similarities and differences are between the 2. So we do also consciously focus on that, as well as it being part of the experience. Although, as I say, it is also very much part of what students are practically learning to overcome when they work in their practical project teams. In terms of data-oriented thinking, again, in the theoretical stream of the programme, we look at the law of privacy, we look at how data is gathered, we look at how important it is that that data be reflective of the situation in which it's going to be used, that there not be discrimination and those sorts of things. And as I mentioned before, from the second year of the course onwards, it's been possible with Matthias's help for the practical projects to include the option to use NLP with a series of data sets. So again, quite a lot of ways in which students can develop that data-oriented thinking. Agile system and design thinking. In the second section of the autumn term, in our theoretical stream, we look at how law and practice might be automated, which bits of practice are prime candidates for that to happen. We think about the problems that we're trying to solve, and we think about which of the 2 disciplines can help to solve those problems and which moves each of the 2 disciplines need to make in order to solve those problems. And we also have, as part of the practical project stream, a specific design thinking workshop for the students. In terms of commercial awareness, the students at the end of the course have to present their practical project as a kind of pitch. It's not a real pitch, but we make it seem like one, and we give them that experience. And as I say, they have all the way through their practical projects this fantastic panel of mentors from the legal tech industry to draw on and talk to about the commercial aspects of their products, who would be likely customers, what would be the drawbacks and what would be the strengths, what would be the things that somebody to whom they might be selling such a product would be looking for, and so on. And we also consider that as part of the automation of law stream, which takes place on the theoretical course in the second part of the autumn term. When we're thinking about which parts of law can be automated, we think about what the commercial pressures and incentives might be there. And finally, the law and ethics of digital technology, which to some extent was the subject of our last week's seminar. This is very much the focus of the whole of the spring term's theoretical sessions of the course. We look each week at how a different area of substantive law is going to need to adjust to the technology in that area. So however ordinary a lawyer you think of yourself as being, whatever your area is, the chances are you will have to deal with some questions in the future relating to digital technology. And so through that spring term, we go week by week with an expert from a different area of law and a computer science expert, and we talk about what the challenges will be in that area. So we look at about things like algorithmic collusion in competition law, digital evidence in criminal law, algorithmic discrimination in employment law, algorithmic decision-making in judicial review, digital assets and cryptocurrencies in property law, impacts on intellectual property, tort liability for for autonomous systems, and so on. So the idea is that overall, over that course, over the 2 terms of the course, through both the theoretical sessions and the practical projects, the students will develop some of those 5 skills that Václav was referring to earlier. And so I will pass back to him.
Yes, so I mean, it's all not only looks, but it actually is great when we do this in a controlled environment in universities. Well, we know that there is this significant learning need in the profession. And as Stuart has mentioned in this bigger picture at the beginning, people coming from universities, they just make up this tiny proportion of the workforce that's coming out there. So we should be focusing on the industry and how the industry can be upskilled. There's, by the way, also in the latest national AI strategy, so there is a very, very strong emphasis on the absence of skills that prevents us from using the technology. So this will be the focus of the nearest future more broadly. But in the law, obviously, as much as I would imagine in other professions, there are these very important practical constraints. One, obviously, is that lawyers are normally very busy doing their daily tasks for providing legal services, and so they do not have as much time to train and develop themselves. And when they do, there still is just a limited amount of training that they can do within a year or within a month. And so they choose very carefully what they will do with that time. And given that they should primarily provide legal services, so normally they would spend most of their time focusing on specifically legal training rather than enhancing their digital skills. And even if they do decide to enhance their digital skills, so what we see actually in this arena is that there are not that many opportunities, right? So there is not as yet any provider of some comprehensive training, certainly not one that would aim at all those skills and learning needs that we've identified. And so the way how lawyers typically go about this, what is, and we learned this from the interviews, is that they either train themselves just by way of exchange. So one lawyer comes to another law firm and gives a talk, or they even go to their clients and give talks to their clients. And by doing this, they learn new things, and they have to upskill themselves on their own. But what we wanted to do in this context is really to hit the spot and help to satisfy this need by trying to offer or develop some learning program for the industry, for the professionals, that would allow them to upskill themselves to gain this confidence and the knowledge and skills that they need in a relatively short time, so that given these practical constraints, that they can actually help and move on and start at least looking into how they may enhance their legal services by various technologies. So what we did is that we started and launched in 2020 our Oxford Law Tech education program. This is a screenshot of our website. If you want to learn more, you can obviously go on the website and browse it. But so far, we've only went through our piloting stage, during which we have delivered training to 700 participants. This pilot stage was run in collaboration with, by the way, we have them here on the panel today as well, with our colleagues from Slaughter and May and the Government Legal Department. So we wanted to also look at these skills needs and how they might be satisfied both in the public sector and both in the private sector. It was partly a matter of choice, but also partly by necessity. So we delivered the program fully online, but actually it turned out that this allowed for a lot of flexibility, and so I'm sure our panelists may say a word or two about that as well, but it allowed us to actually deliver the training to all these 700 participants, which I doubt would be feasible in a physical setting. So that was an interesting learning for us as well. And so what we did was that we piloted these two modules, one called Digital Literacy, Law and Computer Science, which we run with Slot and May, and the other one was called GLD AI University, which we run with the Government Legal Department. Just very briefly to put this in the context of those 5 learning needs. So digital literacy, law and computer science pilot focused primarily on bridging the mindset gap. So there we really focus on the distinctions between the 2 disciplines and how they might be bridged within the firm. So it was all firm-wide training where we brought people from various levels, so not only senior lawyers or not only other business professionals, but we brought them all together. And with the GLDA University, there we focused primarily on the 5th area, so the law and ethics of digital technology. But we also delivered some primer unit for them to understand how artificial intelligence works and actually what the basic parameters and limits of the technology are. Now, at this stage, we really want to get to the point where we will be able to constantly deliver some intensive, short-term, but comprehensive training that would hopefully serve as a point of reference for legal professionals. Because as we've mentioned, there are not that many opportunities as yet, and even if there are, so lawyers do not share this common ground, which would then allow them actually to be more efficient also in their collaboration and in developing various new solutions. To do that, we have actually successfully secured some follow-on funding, which you can see here on the slide. So this allowed us to grow our production team. So we are very lucky to have a lot of new colleagues on the team who help us to now deliver new units. So hopefully in March, we should have 15 learning units. Just to give you an idea, this should be divided into 3 tiers according to their difficulty, so that everyone, depending on their background knowledge, can actually participate in this program and benefit from participating in the program. And obviously, we couldn't have done it and couldn't do it without an intense collaboration and ongoing discussions with our industry partners, the GLD, Slot and May, and now also with the Office for AI. I'll stop here. It's 3 o'clock now. So if you're interested in the program, then there is a contact and the web page. And if you want to learn more about the research outcomes that we presented here today, so there you can see titles of the 3 papers on the basis of which today's presentation was made. And I believe they also will be posted on the conference website. So thank you, everyone. And now I'll hand over.
Thanks so much, Václav, and thank you to all speakers this afternoon. So that's this section of the seminar from the Oxford side, and now I'm very pleased to be able to pass over to Richard and the comments of our panellists. If you are in the audience, please don't forget that you can always add questions in the Q&A on your screen.
Becca, thanks very much. And congratulations to Oxford for the law school for what I think is just and of course, computer science was a fantastic program of work, and the leading to this, I think, very exciting educational program. It's been a remarkable journey you've been on over the last few years, and I think it really is world class what you've delivered. So very exciting. I've been asked to chair this session, and the way we've decided we would run it is I'm going to offer a few observations of my own, and then we have, as Becca said, we have 4 great panelists who will each make a contribution, 7 minutes each they're going to present for. We'll have a conversation amongst ourselves, and then we'll open it to the metaphorical floor. If you, as Becca said, would like to leave your questions and Q&A, please do. That'll be great, and I'll pick them up and we can take it forward in fairly rapid fire format. So let me just make a few observations by way of introduction, and perhaps just to come at some of this from a slightly different direction. I often tell the story of a very nerve-wracking presentation I had to give in late 2017 to 2,000 neurosurgeons in Boston. And they asked me to speak about the future of their profession. They asked me, what's the future of neurosurgeons? And this was based on what we'd done in the future of the professions. And they asked me to be controversial. So my opening line at the presentation was, patients don't want neurosurgeons. And there was a kind of gasp in the audience. But I said, patients want health. For a particular type of health problem, I said, you're the best answer we have today. But my guess would be in 40, 20, I don't know how many years' time, but people will look back and think it's unbelievable we used to cut bodies open, because the future of healthcare, of course, is non-invasive therapy and preventative medicine rather than better surgery, or indeed even robotic surgery. But it got me thinking more widely that the question we all ask ourselves, what's the future of neurosurgeons, is the wrong question. I should have been asked, how in the future will we solve the problems to which neurosurgeons are currently our best answer? And I want to say to you that that's the mindset I think we need to have in thinking about the future of lawyers. We're always asking what's the future of lawyers, and we use the term lawyers throughout this kind of discussion as if that's the constant. But what we should really be asking is how in the future will we be solving the problems to which lawyers today are currently our best answer. And we've also in the future got to think, what kind of problems will there be in the future to which we anticipate people broadly who know about law will be the best answer. But if you are constantly thinking about lawyers as part of the answer, then all you're ever going to be doing is tucking and trimming, streamlining and optimizing what lawyers do today, rather than thinking more fundamentally about what value we bring to the profession. So that's one observation. Second observation relates to this is, what are we training young lawyers to become? And I think by and large, Oxford and others as exceptions, but as I visit law schools around the world, particularly online, I see we're still essentially training lawyers to be 20th century lawyers, one-to-one consultative advisory providers. And we're thinking that technology is an extra set of tools to help them along. We're not thinking far more fundamentally that a lot of the work that lawyers will do today will not be done by lawyers in the future. It might be done by less qualified individuals with the support of technology. It might be done autonomously with technology. But if we are continually thinking that technology is something you graft on either to legal practice or to legal training, we're only going to get to a slightly more polished version of what we have today. And this takes me to artificial intelligence. And as some of you know, I wrote my PhD or DPhil in AI and law in Oxford in the early 80s. So I've spent 40 years thinking about this. And I say with a little bit of confidence, therefore, I genuinely think that amongst the pundits and the bloggers and the columnists just now, almost all the short-term predictions being made about AI and law hugely overstate its impact. However, and I think Europe was saying something similar, in fact. However, and this is more controversial, I suppose, I think almost all the long-term predictions hugely understate its impact. So do I think AI is going to transform the work of lawyers and law schools over the next 2 or 3 years? Not at all. But by 2030, looking longer term and into the 30s, yes, I think there's going to be pretty fundamental change. So that, I think, collectively gives us all a challenge. This is the decade, I suspect, during which, in ways we cannot predict or expect, and again, you think Europe's powerful on this point, I think we're going to see I talk less about AI and more about increasingly capable machines. Our systems are increasingly capable. They're taking on more and more tasks, many of which historically we thought could only be undertaken by human lawyers. That's the interesting phenomenon. And in that context, it seems to me that in terms of law firms and their strategy, in terms of young lawyers and their careers, there's only one big question to be asked, and that is, do you compete with these increasingly capable systems, or do you help build these increasingly capable systems? By competing, you're saying, I hear everything that Richard and others say about AI, but there's lots that lawyers can do that machines will never be able to do. That's at the heart of our legal business. That's at the heart of my career. And I'm going to focus essentially, I would say, on competing with these emerging systems. And I'm not saying that's wrong, but I think it is beginning to swim against the tide of these increasingly capable systems. I'm also saying, actually, I don't think it's nearly as much fun as the alternative, which is to build the systems that replace our old ways of working. Whether or not one look at the law office or our courts or access to justice, the whole shooting match could do with considerable overhaul. We really aren't offering sufficient access to justice. We really aren't, it seems to me, helping people around the world to understand and enforce their entitlements. Of course, the well-off in major organizations can instruct outstanding law firms, but by and large, if we're trying to improve the legal health of our communities, I think we need to work and think differently. And so what could be more exciting than building the systems that replace our old ways of working. And that's why I say to young graduates coming through, don't just take the baton in front and become another 20th century lawyer, be one of the architects of this new way of working. And that completely, I think, changes our way of looking at legal education. I still maintain, and Becca cited what I said, I don't think any of this displaces the need for fundamental legal education, but I think there's something on top of what we are learning just now, and it's true in all professions, which is an entirely new way of making practical expertise, as I call it, more widely available. Fourth observation and penultimate observation, really, I wanted to make, or maybe in the circumstance, I'll make it my final observation, is building on something Matthias was saying about tasks. And economists very much look at AI in terms of tasks. And the preoccupation of most people thinking about the future of legal work is to say, well, what are the tasks that lawyers do? Which of these could be done by machines? There's lots that couldn't be done by machines, so lawyers are safe. And that's a huge oversimplification, but it pretty much summarizes a lot of the publications we see in the future of AI. And I think that's actually just fundamentally misguided. It's not that it's not helpful, it's just that it doesn't see a bigger picture. And that is that the impact of AI is not in task substitution, it's actually in enabling fundamental systemic change. Let me give you two examples. Due diligence, a fundamental task within corporate legal work. And we're seeing the emerging technologies of AI and others that help essentially undertake this work at the level of, if not higher than, junior lawyers. And that's the kind of debate people have about the impact of technology on M&A work. They're saying that we look at AI, what is it that human lawyers do? Oh gosh, due diligence, that's something we could replace. But there's an entirely different approach to due diligence, which one hears very many commercial people talking about. And they say, well, actually, why don't we just take out an insurance policy in relation to a whole bundle of risks that could arise from obligations we'd be taking on board if, say, we acquired this company. Now, if one moves away from lots of junior lawyers or AI reviewing contracts to saying, actually, that's not the way we manage this risk at all, we manage it by insurance, you're then into the question of, I wonder if there's different tools we could use for insurance. There's no question of task substitution there. The task dissolves, it disappears because it's a new business model. This, I think, is where people misunderstand Clayton Christensen's work. And he was clearer in his later work about this. Disruptive technologies are not so much disruptive of tasks, they're disruptive of business models. The reason introducing insurance as a different approach to coping with the risks arising from buying a business, introducing that is not fiddling at the edges. It's a fundamental disruption of the underlying operating model, if you can put it that way, or the business model. Here's another example, and this is finally, when we look at online courts, which is something I've been preoccupied with. And the idea that in the future, at least for low-value civil disputes, I would say, if we want to make ourselves proportionate, we shouldn't need to meet in physical courtrooms at the same time and present oral evidence. We can present our arguments and evidence in electronic form as an asynchronous process. Now, why I think this is very interesting is that most people say, well, take the work of an advocate. No robot could ever stand up in court and give a soaring peroration, or however you want to put it. And I don't disagree with that. But frankly, if you've not got oral evidence, it's not a question of task substitution. If you use the model of online courts I recommend, that's a systemic change. So I'm urging people to think, when they're thinking about the impact of AI, not just about the individual tasks, but whether or not it can bring about this, as I say, fundamental systemic change. That's all I wanted to say by way of introduction, to poke and prod a bit, to hopefully widen horizons a little. What I now want to do is go to the individual panelists who are each going to set out their stall. And first up is Ruth Ward of the Government Legal Department. Ruth.
Thank you, Richard. I've known you a long time, and it never gets any easier to be the person that follows you on a panel, but I'll give it a go. And to kick off, I'd just like to offer a few reflections back on the research work that's been undertaken by Ewart, Rebecca, Vaclav and Tom and colleagues in this work package. And I know it's always safe, Richard, to echo what you say. And you said at the beginning of your words, what a fantastic piece of work. And having been fortunate enough to be involved in the launch conference for this research back in spring 2019, in my previous role at Allen & Overy, and then subsequently to have the opportunity to get involved in developing the GLD AI University in my current role with GLD, the Government Legal Department. I'd just like to take the opportunity to offer a few reflections back on the research. So that the GLD AI University, as Vaclav said, we piloted successfully a couple of times. It was positioned within our department of 2,000 or so lawyers as an introductory course, and very much targeting the particular role of my legal colleagues at the Government Legal Department as lawmakers, as well as advisors on the law. And it focused, it started with a session by Professor Tom Mellom as a primer on AI, and then covered public law implications, algorithmic management impact on employment, and also ethics. So if I look back to the start of that journey in March 2019, when I was at Allen & Overy and I was working with a number of our client legal departments at that time, thinking around, the knowledge and skills that lawyers needed in the fields of legal tech and AI, there was a strong sense that really everybody was finding their own way. Diverse paths were being taken. Undoubtedly, a few cul-de-sacs were followed, and it was all quite confusing. There were big doubts about, what sort of training was needed, what were the important knowledge and skills gaps, what level of lawyers needed that training, and how could that training be provided. And that feeling of isolation, I sense, was compounded really by the behaviour of a lot of law firms at that time in using, their work in AI and legal tech as a differentiator for their client offering. Law firms, perhaps including my own at that time, Allen & Overy, saying we got the treasure map for this and not particularly sharing that publicly. And I have to say, in fairness to the lawyers, there was a sense of that also on the computer science side. I mean, personally, I'd seem to go to numerous lectures on an AI and legal tech, and every computer scientist giving the talk would give a slightly different take. And so every time I came out again without a clear, simple statement of what AI might or might not be. So for me, reflecting back, this work package, this research was really important, and its findings, and I've had the benefit of looking at the papers and the articles coming out of it, are of sort of fundamental and practical importance for me, and I suggest for many others. And the value of the outputs of the research come not only from what the focus was, but also how the research was undertaken. So for me, the work stream really sought to grasp with the tech for law as well as law for tech. It was sufficiently broad to really capture everything. Through the Oxford course that Rebecca has talked to us about, it's very much positioned as a shared journey, a shared learning journey for both lawyers and computer scientists. And I don't think I can overstate what I see as the importance of that being a shared journey. And as part of that, both on the Oxford course and on the OLTEP, the in practice courses that we in Slaughter and May piloted, there was practical testing of what the data suggested. And if you have the benefit of looking at the papers and the articles, really see how valuable the feedback from the course participants. Rebecca, what you were saying just a few moments ago about guest speakers not being able to tell whether the questions were coming from the computer scientists on the course or the lawyers on the course, really interesting. And finally, and perhaps most importantly for me, it really sought to address the behavioural as well as the academic challenges. Those questions of confidence, permission, language, the need for lawyers and technologists to be prepared to explore being bilingual to an extent, but even more than that, to be motivated and curious, to understand the difference in mindset and what that should mean for the opportunities to work together going forward. And that focus on the how as well as the what of the research, for me, is then brought out in the 5 sort of common core, as you described them, as Oxford colleagues described them, knowledge and skills gaps. And, you know, perhaps there'll be an opportunity for us to pick this up in Q&A. But one of the most interesting things for me was in the papers coming out of the research is what's positioned as the differences between the computer scientist mindset and the lawyer mindset, and the value of not only of recognizing those, but actually, you know, to provide opportunities for, you know, that thinking to be brought together, but also that sort of shared experience. And that's something I think that is you know, there's so much sort of opportunity in thinking how one can build on that going forward. I think I'm probably up to my 7 minutes, Richard, but perhaps there'll be the opportunity to come back to some of those things around mindset in Q&A.
Yeah, thanks so much, Ruth. And it's so helpful to have your perspective, both more distantly from being a Magic Circle firm and now more recently in the government legal service. Thank you. And can I remind people listening in to please do drop questions into the chat session. We can pick them up a little later. Next up is Nigel Spencer. Are you ready to go?
Thank you very much, Richard. And pleasure to be here this afternoon. Thank you very much for asking me to say a few words. And it's been so interesting. And Ruth, you mentioned the opening conference. It's so great to come back and seen the beginning and the end and seen all the pilots and the experiments you've done. So many congratulations. Absolutely fascinating. For those of you I don't know, so my background for about 15 or 20 years was in developing lawyers. So I worked in some city law firms looking after learning and development, as well as whether that was the graduates or also involved some undergraduates at times, right through to the partners. So working on all those different areas. And also did some more organizational development type projects. So built an innovation hub at one of the firms when we needed to think about how we needed to rethink service delivery and get clients involved in that conversation. So various projects, and now in my current role, looking at lifelong learning strategies and working with industry as part of the law school where I am. I mean, Ruth, as you said, I thought it was so interesting seeing the papers that you produced, that the team produced. Those almost the picture you've painted there of almost the common skills, as you called them, for your legal technologists, and the 5 areas that you've looked at on your pentagon there: the mindset, data orientation, agile thinking, entrepreneur way of thinking, being open to failing and trying stuff as well, commercial awareness, digital ethics. I was pleased to see that at least when I had a go at doing some personas for the future, that I wasn't too far out in some of the research that you've done, which is nice to see. So, but that all made, you know, it really sounds sensible to me, you know, those 5 skill sets, and very interesting to hear how that's panned out, as you said, in developing that through the courses. The question for today really on some of the sort of subheadings was, how do you build capacity in relevant skills, and how do you train for a multidisciplinary future? And just to note that those words begin with how. So I thought I'd just spend my few minutes, Richard, and everyone, just thinking about perhaps some of the educational method point here as well. Well, in my world, over all those years when I held those roles, when we talked about building capacity, we were thinking about strategies almost through what we called an employee life cycle. So it might be strategies to attract, strategies to retain and develop, and then strategies also to build what we call organizational agility. So building those skill sets that perhaps we could utilize people in different parts of the organization. So it was really with those lenses, I just wanted to say a couple of minutes on those different areas, really. So if we think about strategies to attract, just one thing over the last 2 or 3 years, I think that's an interesting development is the career path. And we've talked about the shape of careers. We talked all about the alphabet of different skills that people are talking about. One shift that seems to me to be happening, which is interesting, is it used to be the case a few years ago that even when some of the tech roles started in firms, it would be the case you went in on the same career path, but then branched across. So I remember, I think it was Linklaters announced once, they said, you know, you can come in on a path, but now for associates, you can go across into the tech team and it's a permanent role shift. So that's open to you. But I think what we're seeing now, which is interesting, is those career paths starting right at the beginning of people's careers, at career entrance role. And just over the press in the last few weeks, when I did a search, Addleshaw Goddard, a grad scheme in tech and innovation, Ashurst, a new law career trajectory, McFarland's law tech grad scheme going into there as well with 2 years in their legal tech departments. So if you begin the career paths right at the beginning, then you go to my point of attraction, you go to that thought of the challenge for law firms becomes actually, well, we're then asking for a different skill set. We're actually saying this is a career path open to people. So how do we attract? And beyond salary and benefits, almost what's the culture that we need to create in the firms, I think is an interesting question. If we are going to develop this as a whole career path, so that attraction point. Now, in terms of the developing and retaining, and almost that part of the capacity building, I suppose we could think in different ways. We could think about what you need to develop, perhaps before people have entered the place where they're working. You could then think about the executive and CPD point we've made about what they need to develop while they're in that, while they're being employed and working, and then how we need to develop people as well. So just to begin briefly with the what. Again, we've talked about the personas, the skill sets seem dead on to me in terms of all the ones you've worked on in the project. I think just in passing say, I think there is this tension I think you referred to as well about when we're creating multidisciplinarity, should that be in individuals or should that be teams working together and to collaborate? And I think all the client feedback that one hears of saying we want people to be collaborating across firms and across disciplines, I think just gives us an interesting question there in almost what that looks like in the future. You've talked a lot about mindset development, and I couldn't agree more on this. I think what we're touching on with mindset is almost touching on people's identity. So if we're thinking about, who do they think they are? What do they think their job is? And almost, do they understand what good looks like to add value to the clients in their situation? So I think all of those become really interesting issues for the mindset development. And from the experiments I've tried on this, where I've tried to test the shifts in mindset when we introduce some courses, I think my thought would be starting early is a good idea, and then you do have a chance to shift the mindset. So however much of the percentage of the workforce we do affect through tertiary education, I think it is a great idea to start that mindset development then, or at least very early when they're at the beginning of their career paths in firms. And if we move to the how now, I think one of the, and this was a point really of, I think came through in some of the papers you wrote around how do we keep the curriculum agile, especially in a sort of in a university environment, for example. Again, should it be exec ed, should it be CPD or formal tertiary education? And one of the things that came through to me very strongly was one of the conclusions you reached that you said, I think in one of the papers, the projects and the experiential learning were at least as important, if not more important, than perhaps some of the more classroom-based activity in terms of the changes you noticed. And so just really the thought that left me with was, what if we really stretch the bounds here? What if you create an environment where there's almost a permeable membrane out to the outside world, where people are coming together? Yes, they're in a law school, but employers are throwing problems into a lab-like environment. You have people coming together across the world where they're actually networking internationally, and all the benefits that agile and sort of flexible thinking that would inevitably create. So almost can we have that? I know the phrase is already out there, law without walls, kind of thing. And just to end really, Richard, it took me back to a talk I heard by Jeff Morgan a few years ago. Jeff, when he was head of Nesta, the Innovation Foundation. And just to quote a few words and phrases from some experiments he was doing and he'd seen in different universities. And I'll just pick out literally words and phrases. He said, with some of these more project or experiential type activities, he said, what's great is when we put students up against difficult problems, they draw on different disciplines, they're collaborating with outside organizations. And this isn't a replacement for the classic core of university education of mastering a discipline, but what it is doing is being an important complement, which I think is what we've been saying this afternoon. And he also said, it also re-emphasizes perhaps one of the founding principles of some ancient universities, as he called them, that wasn't me, a focus on questions rather than answers to drive really deep learning. And so what did he suggest, interestingly, given the project and your findings? He said, I think this is it's really well approached if you use projects, if you use cross-disciplinary teams, and if you present people with unsolved problems, which are real problems that they have to work on as well. So that was what struck me. So I think all of the work you've done just as I say, I was interested in just talking a little bit in my minutes to the how there. And just to end, you'll know that when I started speaking about kind of multidisciplinary approaches a little while ago, I deliberately used my classical Greek version of the word, so I'll just add to a more alphabet approaches here, when I said that it was more poly, many, and techni, skill. So I used that word because what it seemed to me is that we need to think about poly meaning the breadth, but also the skill, so very much the learning by doing, which you've really emphasized, Becca, you and Vaclav. And that for me came out of your project as a really interesting bit of key learning as well. So just to end really, I'll end by saying that I think it means, you know, let's be brave and let's be more, I'll use polytechnic in the sense of the word, in that full sense of the word, to create the learning technologists, both in the what and the how. Create more placements, use the projects, and let the outside world in, or rather, and that's the way of almost making the education move as fast as the outside world, I think. So that what we're doing in effect is almost creating a situation, let's say, which is almost like a living lab for creating these people of the future, Richard, so that it can be as flexible as you say it will need to be.
Thanks very much, Nigel. That's really wide-ranging and fascinating, and drawing together many aspects of your own background. Can we keep the questions coming? There's more. It's a great thing to have observations, but there's more observations than questions, and we want to stretch the panel today, not just to hear from them, but to poke and prod a bit. Next up, Emily from Slaughter May. Emily, over to you.
Thanks, Richard. Hi, everyone. Hopefully you can hear me. My name is Emily Liu, and I'm joining you today from Slaughter and May. I am one of Richard's 20th century lawyers. I started the early part of my career as a litigator. So during Rebecca's talk and Vaclav's talk, I was desperately assessing myself against those 5 core skills to try to see if I had any of them. And the one that resonated most with me was experience with giant piles of documents. So I've definitely got that one. In the latter part of my career, I moved away from sort of that fee-earning client-facing side of the law, and now I sit in Slaughter and May's innovation and legal tech team. So Richard, I'm at the coalface of those theoretical attempts to apply those AI due diligence tools to the real buying and selling of massive companies. So maybe we can have a chat about the realities of that another time. So what are we talking about today? We're talking about tomorrow's legal teams. This question is never far from our minds in my team at Slaughter and May, and we're lucky enough that we have this dedicated innovation and legal tech team to think about things like this. The way we think about it is in relation to 3 distinct communities, and what I think I'll do is spend a couple of minutes just talking about those 3 communities and what we're doing at Slaughter and May to try to address this question of what are tomorrow's legal skills going to be like. And those 3 groups are our current lawyers and legal professionals, our future lawyers, and our future non-lawyers. So taking each of those in turn. The first one, our current lawyers. It's obviously business critical to ensure that we're educating our current lawyers and legal professionals for future practice, not current practice, future practice, and to ensure that they're equipped to advise our clients' businesses through this proliferation of new technologies such as AI. So the approach that we took to that challenge is to make available to everybody in our firm, not only our lawyers, but also our business services wider teams, an innovation training program. That's something we designed in-house and which we deliver via a mix of workshops, in-person sessions and online sessions. And when we were designing that program, we came up with 3 main strands that we wanted to cover. The first one, and the one that's most relevant to today and to Rebecca and Tom and Vaclav's amazing work, is digital literacy. So what we mean by this is ensuring that we and our lawyers have the understanding and vocabulary around innovation and technology to advise our clients, to identify innovation opportunities, particularly those that are technical in nature, in the provision of legal services. We also place emphasis on the differing mindsets of the lawyers and technologists, just like the Oxford programme tried to do, and how these groups can collaborate effectively. So we were involved with the Oxford programme. It was brilliant, the virtual series, and we really loved the aim to try to fill those gaps between people's understanding, the differences between the technologists and the lawyers. Rebecca, in your article, I was absolutely fascinated to see not only whether those differences in mindset, differences in terminology, but crucially, differences in snacks. So please, can you tell me which snacks did the lawyers want and which snacks did the computer scientists want? Who won? Was there collaboration? How that played out? I need to know. Second strand, over and above digital literacy, the next one is productivity. So our innovation strategy at Slaughter and May involves improving our processes, becoming more efficient and effective with the resources that we have. So most recently in 2020, 2021, we're really focusing on being productive and mindful with our use of technology. Technology can be an amazing enabler, but it can also take you over and control you sometimes. That's not always necessarily the best thing to do. So obviously changes in working practices that have come about as a result of the pandemic have really increased our understanding of the reliance that we have on technology. And finally, the third strand that we take in this innovation training program for our current lawyers is creativity. So this talks a little bit about design thinking, something we've heard about, touched on briefly today. What is design thinking? It involves diverse teams collaborating on generating, testing, and selecting great ideas to address internal challenges we have at Slaughter and May and challenges that our clients face. And that's intended to help us think creatively about the way our legal services and documents and processes are created and delivered. Maybe, Richard, this is the answer. Computers, do you build them or do you compete with them? Well, I don't know, maybe I'm speaking out of turn, but if you focus on that human stuff, that creative stuff, that design thinking, human-centric, user-centric stuff, I'm not sure computers can do that. Definitely not yet. And I would guess not even in 2030 either, but maybe I'm wrong. We shall find out. So this human-centric focus that design thinking has seems to be an overlooked thing, a really overlooked skill that we kind of forget about, and that tomorrow's legal teams, I would submit, need to have in counterpoint to these more obvious tech-related skills that spring to mind. So that was a really quick run through of what we're trying to deliver to our current lawyers. What about our future lawyers? We've got this big thing going on in the moment in the legal community, which I'm sure you're all aware of. The traditional training contract, which has been in place for decades, is being thrown out, and qualifying work experience is going to replace it. So these changes that are being thrust upon us by our regulator, the SRA, present us with an opportunity to sculpt a new training contract. And we at Slaughter and May are in the process of considering what the trainees of the future are going to look like. And we're trying to articulate what knowledge, skills, and behaviours do we want to see in our newly qualified lawyers. And Rebecca's, Tom's, Vaclav's 5 core skills would seem to be a really good starting point there. We are seeing that universities are starting already to include these elements in their law degrees. So good news, it is already happening. Sometimes individual modules, like where you have to develop a chatbot, or where you're looking at ethics and regulatory concerns around the use of AI. The joint honours types of programs like law and computer science, we're seeing that as well. And the result is our trainees who land with us at Slaughter and May are already beginning to come with some level of understanding that they will be using legal tech as part of their role, and they will be working in multidisciplinary teams. Funnily enough, one of the challenges is managing their expectations. The reality on joining can sometimes be a little bit underwhelming when you've just spent years and years talking and studying about how AI is going to transform your life as a lawyer. So that's an unexpected challenge that maybe we haven't talked about today. Finally, the third community I wanted to say a word about is our future non-lawyers. The title of this session is not tomorrow's lawyers, it's tomorrow's legal teams. Tomorrow's legal teams will probably contain lots of non-lawyers. Already we think data analysts, legal technologists, legal project managers, these people sit at the junction between the business of law and the practice of law, and they're going to be more and more central. And those things I mentioned, what about all the new jobs and new career paths that we haven't even thought of yet? Collectively, we refer to these as legal operations, as a convenient term to encompass all of that stuff. And it will be of key importance that individuals within these multidisciplinary teams will be able to work together, emphasizing the importance of communication, collaboration, more human skills across those different disciplines. And that's something Rebecca, Tom, and Vaclav, you obviously observed in practice. We're already seeing the success of some multidisciplinary teams that exist already in Slaughter MA. We have legal project managers who work directly on client matters as a member of the legal matter team. We have a technical e-disclosure team that sits within the disputes legal team. We've also developed, I think the previous speaker spoke about some of these. In Slaughter MA, we have one, a legal operations grad program. This is a brand new thing. The idea is to accelerate the development of junior talent, the pipeline of junior talent coming through in legal operations. And that skill set is developing and has become increasingly significant. This is a 2-year on-the-job learning program, 4 rotations. They sit within business intelligence and pricing team, legal project management team, my knowledge and innovation team, and a client secondment. They have an internal training program that we've designed. They also have an external training program with a consortium of other law firms as well. And the skills that we're trying to develop in those legal operations graduates, the skills include legal practice, innovation, document automation, legal tech process design, business intelligence, data analysis, legal project management. And the applications that we received for that course, for that training program, came from people with a really wide range of backgrounds. Some of those had studied law, some hadn't. Those who had studied law had usually done at least one of their modules on legal technology or another legal ops related subject. So the work which is being done at Oxford at the moment that we've talked about today and that you've identified as being needed from universities is already happening, at least to some extent. We're seeing that coming through. And that's really all I wanted to say.
Well, that was great, Emily. Thanks so much. Particularly interested, and we must have a discussion about this, about design thinking, which I think is, of course, integral to new forms of legal service in the future. But meanwhile, to run our anchor leg, Andy Unger, over to you.
Hello, everyone. Rebecca and I met teaching about our practice at a Legal Geek event, and I'm going to respond to this body of work really from the perspective of how we're addressing these issues at London South Bank. The journey for us started about 4 years ago. We went to a conference about the use of technology in legal education and encountered an analytics tool called Case Crunch. And we came away from that conference realizing that the future was now. Things that have been talked about, we realized they were now happening. And we had concerns about whether or not our students were aiming for jobs that wouldn't exist by the time that they graduated. And we felt we had a moral responsibility to address that. So we spoke to the computer scientists at the university. We had a hackathon, and the upshot was for the last 4 years, we've been teaching a module on law and technology, which is taken by all of the computer scientists in the final year and a body of optional students from law. And we teach what is law and technology. We teach legal design thinking, project management, and we use processes like Agile Scrum and tools like Jira, and we teach teamwork. And we use real clients and we ask them to solve real problems, at least to the level of a prototype. We take lawyers from our legal advice clinic and we work for local, well, we recruit clients from local law firms and local charities. So we've been building tools to support the legal advice clinic, and we're just about to go online with a racism reporting tool that we built for a local charity, the Monitoring Group. So we've been exploring this territory, it seems to me, at ground level between the hedgerows. And so when I read the outputs from this research project, it was very exciting and very enjoyable. And I think Rebecca and her colleagues are really to be congratulated for the maps that they've produced. It seems to me that we've got an overview of the legal and education training needs from my perspective, and a solid foundation for building a practice of teaching law, technology, and innovation in higher education. So reading the documents, I was sort of able to conduct an audit of our own practice. and we can see from augmented lawyering that jobs, there seems to be evidence that the jobs are changing. It's not happening super fast. There's a lot of inertia, I think, and it's a conservative profession. But we can expect new roles for legal experts. Rebecca and colleagues call them legal technologists. And they're going to work in multidisciplinary teams. So that obviously fits in with the approach that we've taken from our course. And we're aware of the emergence of legal operations teams, as Emily has just been talking about. And from our point of view, is situated in South London with a legal advice clinic and part of the Southwark Legal Advice Network. There are also important and exciting opportunities to try and address unmet legal need using AI. We've collaborated with the Access Social Care chatbot, but also through the intelligent application of innovation and automation. And if we look at the needs in terms of law tech adoption and training, and that report, it still remains a question, I think, whether or not technology is yet significantly impacting on the volume of available trainee and newly qualified jobs. But there is a sense that automation ought, over time, to reduce the number of places available. And that has implications for law students. Are they going to qualify through the traditional trainee solicitor route? Are they going to come through paralegal roles and through legal operations teams? These are things that we need to sort of discuss with our students and to prepare them. The report identifies also that there is a relatively low level of law tech training in the legal profession. Lawyers need to be familiar with non-legal specialisms, and I think we need to include that in our practice. Unlike the Oxford approach, we haven't gone down the route of a specialist LLM, but we've started to embed this practice and try and mainstream it into our law degree. So using the 5 skills and knowledge gaps identified in the report on the education of the provision of technologically enhanced legal services, I would say mindset understanding, yes, we've started to do that. And it's been very interesting watching the law students encounter the computing science students and vice versa. And one of the trickiest things in the project work is when they think they've understood each other and they haven't. And they're building things, but they're not building for the same tool. And when you put the bits together, they don't work. So mindset understanding is something I think that we're working on. Data-oriented thinking, no, I don't think we've addressed that nearly well enough. And I'm going to have a conversation with our team about looking for places within the degree, existing places and possibly new modules, where we could address that. Agile systems and design thinking, yes, this course that we run does that. It's only one module, and there's another question about how we mainstream this. Commercial awareness, I don't think we do that enough. We've had some feedback from employers that our students aren't strong enough in this field, and that's something we need to address. I think there must be perhaps an access to justice equivalent of commercial awareness, perhaps social awareness. I'm not quite sure what it is, but it's not quite the same questions as commercial lawyers working for the needs of commercial clients. It's for lawyers who are dealing with vulnerable clients who've got social welfare, employment, housing problems, and so on. But when you're designing systems and tools, that's very, very much part of the legal design challenge. Digital ethics and the law of AI, no, I don't think we do that nearly well enough. We've got 1 or 2 modules where that's beginning to happen. But again, I completely accept the 5 gaps. They make sense to me from my limited experience of the market. And we will take these things away and think about them. So what are we going to do next? One of the things that we found in the early days of the module, it's not so true now, is that not as many students as we thought were interested in taking the module. I thought we might be turning them away. from the module because it was too full. But students are perhaps as conservative as the profession. So I've asked our first year team who teach contract law to take that module, and we're just starting a new degree, so it's a good opportunity to teach contract law through the lens of technology. And we've invited Alex Hamilton from Radiant Law to sort of talk to them about modern contracting. We're working with a team called Avoca, and we're going to give the students an opportunity to build contracts and reflect on contract assembly as part of their introduction to contract law. We've invited the business school into our family. So now we have a tri-disciplinary approach to the course with business, computing and law students working together. Some might solve business and technology problems. Some might solve business law and technology problems, and some just law and technology problems. I think we have to look at CPD. I'm very jealous of your project there. Overall, I think there's an opportunity here to develop experiential learning, which is a strategy that we enjoy. Richard has talked about the flight simulator. That makes sense to us with an emphasis on the clinical program. But I'd also like to use technology to develop simulation opportunities for students. And the last thing, I think, just law is algorithmic. So we give our students tablets and we give them an e-library of books, but I try and encourage them, I don't think I've done this as well as I could, to use the apps that are available on these kind of tools everywhere, ubiquitously, to explore their own learning styles. And it seems to me, as well as taking notes on cases, you can develop flowcharts on cases, and you're there taking big steps towards algorithmic thinking, but also improving your skills of applying the law to the facts of cases when you're assessed. That's it from me.
Andy, thanks very much. I'm conscious of time. We've got about 10 minutes left, so I think we'll go straight to some of the questions. If I can start by combining two questions, one from David Cohen and another from, it's Miguel, forgive my pronunciation, Pobletti perhaps. So Miguel asks, how can we convince faculty, authorities and colleagues about the paradigm change? David asks, what practical steps do you suggest to be taken to accelerate this kind of uptake within the law schools? I wonder if we could just have brief observations on this punchy stuff from Nigel, then from Becca and from Andy as well. So Nigel, first of all, how can we accelerate the uptake of this kind of awareness and the urgency, as I think some of us would put it, to introduce this into law schools?
So I guess that's a really good question. Thank you, Richard. So what can we do to accelerate? I think there's something here about, the way I've always seen it is, what journeys we're helping people on. And so I think building that perception and that awareness of almost what is the journey look beyond where we're helping them at the moment, I think is probably a good place to start, almost to begin that conversation about saying, okay, what do they need to be ready for? Whatever pathway they're going. As I said, it's interesting. I think the pathways are shifting. So I wonder, Richard, if I'm conscious of time, I wonder if there's something here around just almost thinking of, okay, we sit at one point on their pathway. What does beyond look like? Perhaps I'll start there. And I wonder if that helps get the conversation going of, therefore, what does different need to look like when they're here as well?
Thank you, Becca.
Yeah, really good question. In our case, we've done it really by, it's an option. Our law and computer science course is an option. There is now an increasing buzz around it. And so we're hoping that that means that people are attracted to it rather than being afraid of it. I think fear is very much one of the reasons why people are reluctant to sort of incorporate this kind of thing. People think, oh gosh, I don't know anything about that. That's not really for me, you know, and then they feel perhaps a little bit defensive or scared, and then that sort of puts them off, and then that's where some of the divisions can happen. So another thing that we've been very careful to do throughout our course is that when we do the cultural stuff at the beginning, we look at the interdisciplinary stuff. We say that there's real jurisprudence in this. You know, if you are a very, very standard, very traditional Oxford jurisprudence, there is still a space for you in this course, because some of those questions that we ask are, just like Andy was saying, is law algorithmic? Is that a good way of thinking? That's exactly, you know, a jurisprudential question, really. And so there is home even for the most traditional person on the course. But beyond that, I'm really interested. I'm hoping Andy will say that a little bit more about how he's got the whole of the computer science faculty to join in, because that's sort of the stage we haven't got to yet. As I say, it is still an option within our faculty. It is not something which is at the undergraduate level, as somebody else was pointing out in the comments, which I would love it to be. It's not across the faculty yet, and I'd love to hear more from Andy about how you do get it across a whole faculty like that.
Okay, no pressure then, Andy, over to you.
No pressure. I was very lucky, I think. But computing had a project management core module in the final year. I offered to give them real projects to practice their project management skills on. And after that, they kind of bit my hand off. So it's partly this methodology of having lawyers and others from the community and from the law school itself acting as real clients, or at least simulated clients for prototype projects. And also, to answer the original question, I think that if you're in a particular jurisdiction and you're trying to get your university and higher education generally to embrace these changes, I think you need to capture the opinion shapers in the profession and in the regulators, and they need to give clear messages that this is part of what is needed by the profession, by the community, from legal education. Thank you.
Why don't we take another question? And this is, I'm not sure who's best to answer this, but I'm going to ask Ruth and Emily in any event. It's from Mavish Rani. What can developed countries do to share skills for the future for developing countries? I suppose the question is, how do we have in Oxford a tremendously well-funded project. It's been supported by the government, by leading law firms. How do we make this more widely available, this learning? Because certainly as I travel the world in so many developing countries, really struggling to keep up to date with many of these developments. Ruth, did you have any thoughts on this?
I think the research that's been done, and I hope what follows it is a step in the right direction. As I said in my opening remarks, I think one of the things that's perhaps has held, you know, everybody wherever they are based who has an interest in this space is that so much of the early work, certainly from a private practice law firm perspective, was very much kept under wraps because law firms, you know, particularly global international law firms, were thinking this had suddenly become part of their secret sauce, their secret recipe for success. I think the more that through research like this, which is open to all, and academia really beginning to, you know, get a grip on what this means in practice, you know, brings this into the public domain, that's got to be helpful for, you know, for everybody. And recognizing that, you know, notwithstanding from a legal perspective, you know, the jurisdictional differences, that all the challenges that we're looking at and the solutions to them are global in nature.
Thank you. And Emily?
Yeah, I don't have much to add really. I guess just to say that I suppose the one maybe silver lining of the pandemic has been that it has democratized this and enabled loads of people from all over the world to join. So maybe if we can capture some of that going forward, keep things virtual, then it can be open to more. And I guess the other thing might be sort of pro bono initiatives, outreach things, projects like that, to involve people in other countries.
Thank you, Emily. I want to keep you at the microphone, as it were, because there's another question from Despina, which I think is relevant. A question about how to convince employers of the benefits of such types of skills. And the point is made, quote, "I'm afraid that the general population of lawyers and the legal departments, while this is increasing, it's still quite low." And this is the point that Nigel made. It's observed just on mindset. So maybe Nigel observing this. There are, I find people so frequently who say, I find it very hard to convince those who are leading our firms to see that these changes are coming over the horizon. And how did it come up? Slaughter May, undoubtedly one of the leading law firms, and your firm seems to have recognized. How was this brought about, this shift?
Well, the way change tends to happen in very large law firms, I can't speak for other organizations, is when it's driven by the clients. So our clients are really, really driving this. In pitches, we see massively increasing numbers of questions around innovation, legal tech, efficiencies, project management. And there's been an absolute sea changer over the last 10 years where clients are really pushing their firms, their law firms, to demonstrate how they are bringing efficiencies to the delivery of their legal services. And I think if anything's going to make the management of a law firm sit up and take notice, it would be clients asking for that and demanding it when they're giving the work. And I think that's good news because it filters down, and it absolutely has driven a huge recognition of the importance of this stuff, because it really does affect the bottom line. And happily, not only does it affect the bottom line, it also makes lawyers' lives much more interesting, much happier, increase in well-being, and just makes their working lives much better to be able to bring new approaches and not be stuck in that traditional mindset.
Thank you. And it's worth adding, it's not just clients in isolation, it's clients collaboratively. When you think of organizations such as Clock, where clients are coming together and exercising their collective muscle, which thinking about standard setting and so forth. And that's, I think, over the last few years been a big difference. Nigel, would you like to take us home as well? We've only really got about a minute to run before we hand over to Becca, but any thoughts on that to add? How do you make it happen? How do you convince leadership and mainstream lawyers that this is all important?
So I agree, client voice. I think client voice is critical, as you say, for all the reasons that you said, Emily, completely agree. The other way, if ever I did manage to make change happen a little bit within the firms I was in, it was always by, as my phrase I always used, lighting small fires. Find where the energy is for change in the firm, because there will be 1 or 2 people, or 3 or 4 or 15 who are keen to do something. And then if I had the chance to run a little project with them and then get a chance to have 3 minutes at the partner lunch meeting every 2 weeks, and just had 3 minutes there to say, do you know what, we've tried this with this practice group. Anyone would like to try it? And then you get snowed with telephone calls all afternoon of saying, well, we're not doing that. What's going on over there? So that was always a great way of trying to get some momentum for change. That would be my tip of the day, Richard.
Great practical stuff, Nigel. Thank you, Nigel, and thank you to all the panel, and of course to people listening in or watching who've contributed to the Q&A session. Becca, back to you in our Oxford studio, as they say.
Thank you so much, Richard. And yeah, can I echo my thanks to the panel, both for your participation this afternoon, which has been fascinating and very helpful, but actually also for your collaboration and support right the way through the project, which we couldn't have managed without. We've been very lucky to have you. So thank you so much for all of that. While I'm on the subject of thank you also to our PI, John Armour, for the organising the project and, of course, these closing webinars. And also very important thank you to Beryl, who very often just appears as a name on the screen to all of you, but really, I can't tell you the level of competence and efficiency and patience and kindness that Beryl has shown in getting the whole thing on the road. So thank you very much to Beryl for that. As Richard said, thank you also to all those of you who have contributed questions and been participating in the chat. It's been really interesting to hear from you. I know a lot of you have been asking, where can we see the papers? Can we see the slideshows? I think Beryl is very kindly going to post some links in the chat for where you can see more information. So please do, everyone who's interested, please do stay in touch. This is the end of this particular project, but certainly not the end of our work in this space. So please do stay in touch with us and see what we do going forwards via those websites. So thank you all very much indeed. And yeah, have a good rest of your afternoon.